All right, well, welcome everyone to this Sydney Law School webinar. I'm your co-host, Luke Nottage. For those of you who don't know me, I'm Professor of Comparative and Transnational Business Law at the University of Sydney, which you see behind you on this virtual screen. It was a photo I took of a sunset. It's not bushfire or other disaster. Beautiful sunset the other day here at the University of Sydney. And I'm joined by my colleague, Associate Professor Stacey Strong, who will be kindly helping moderate the concluding question and answer session. But I'd like to begin by acknowledging the local Indigenous Gadigal people on whose traditional lands this University of Sydney main campus is located, as well as several institutions that have helped make this webinar possible, as well as the associated CLUA book project. And so those are the Sydney Centre for International Law and the Centre for Asia and Pacific Law at the University of Sydney, the Australian Network for Japanese Law, and the University of Hong Kong. And many of the speakers today for you are co-editors or authors for that book, but we're also pleased to have along some of the other book contributors. I can see them on the screen already, registered, thank you. And we hope to have another event later towards the end of the year when this book should be off the press. We're delighted to have over 230 people who registered today from around the world to consider our topic, which is Beyond the Pandemic, New Frontiers in Asia-Pacific International Dispute Resolution. Could I ask that you keep your microphone and videos turned off, just so that we don't crash the system, although it's lovely to see some of you, yeah, some faces of some of you before you switch off. You're also welcome, though, to contribute written questions via the chat function in Zoom as the presentations progress. And Stacey will curate those and pass on some of those questions to the speakers for us to discuss in the last 15 minutes. If you want to make your questions anonymous, please mention that when you write a written question in the chat function. And also note that if posing any questions, Sydney Law School is recording and retaining a record of this session, including the chat. And afterwards, the video part will be made publicly available via the Law School's podcast webpage and its YouTube channel. All of those of you who've registered here will also receive an email afterwards directly providing a link to the video recording. You might also like to use the speaker view in Zoom, so that can be turned on the top right of your screen, and it means that you'll only see the screen of the person who's talking at the time. So we have an action-packed program today, and I have to be quite strict about timing, including for myself. Each speaker will address one of the questions that we posed on the event registration webpage, which are often related to their contributions to our CLUA book now in press. That webpage also has a link to my University of Sydney blog on Japanese law in the Asia-Pacific, which has full bios for each speaker, as well as abstracts for their book chapters. So I'm only going to introduce each speaker very briefly today. They're all very eminent, as you will have gathered, but we have to keep moving. So first up, we have Associate Professor Bruno Jetin from the University of Brunei, Dar es Salaam. He's an economist who directs its Institute of Asian Studies and is one of the co-editors of the book for CLUA. He's been asked to provide just a 5-minute update on the pandemic's impact on regional supply chains and foreign direct investment in the region, as this will give us an idea of the actual and potential cross-border disputes and how these might be best resolved. So, Bruno, you have the floor. Thank you.
Thank you, Luke, and good afternoon to all of you. Thank you for organizing this webinar. I would like to go straight to the point because the time is limited. And the first thing we can say about the impact of the COVID-19 on the economy, and more precisely on foreign investment and trade, is that it is a dramatic fall. If we are just focus on investment, the UNCTAD, which is the best international institution that deals with foreign investment, their forecast based on what was known during the first semester of the year points to a decrease, I should say, a fall of 40% of foreign investment compared to the previous year. But this was based, as I said, on what was known during the first part of the year. And they estimate that there will be a slow recovery of foreign investment and international trade in 2022. But if we look at their estimates for 2022, we would still be very below the level of 2019 and very far below the peak of international investment reached in 2015. So 22 is at best the start of recovery and not the return to normal pattern of the global economy. But as I said, these estimates are based on what was known during the first part of the year. And now we have the World Health Organization, which has recently published a statement saying that the COVID is probably here to stay, that the pandemic will last longer than expected. And even if soon vaccine is finally discovered and is effective in curing and preventing the disease, it would take at least several months, up to 1 year, to vaccinate a large share of the population. So it means that the COVID will not be, the pandemic will not be resolved anytime soon. So we can expect the low level of international investment and trade to stay like it is now for at least next year, but probably until 2022. And we cannot disregard the possibility that it gets worse if things get out of control, say in the USA, for instance, or if the new waves of contamination in Europe after this summer shows a return of a high level of the pandemic. So we cannot think that the level of disruption of production will be the one that we have witnessed so far, because most of the countries are now better prepared than they were at the start of the year. But because there have not been any really important relocation of some critical goods within the main economies of the world, and I'm referring more to pharmaceutical goods and medical goods, such as, of course, masks and also gloves. We can expect some shortages of critical supplies with the same effect that the one we have witnessed at the start of the year. So that's the first thing I would like to say, and I would like to move on with what we can expect in terms of transformation of investment and trade. This pandemic happens at a time of very strong tensions between the USA and China, as you know, but now there are also growing tensions between China and Japan and with Europe. So we can expect some trends, growing trends of protectionism and some restrictions that will be put on Chinese investments, for instance, and Chinese trade. To take just one example, Japan has decided to establish a fund of around $2.5 billion to subsidize the repatriation of manufacturing activities from China back to Japan. And this is just a start. I think that we may see other examples in other parts of the world. And if this happens, it will reinforce trade and investment tensions, not only between China and the US, but with some other important countries. And this shows that it will transform the reality of trade and investment, and it will have, with some delay, an impact on the kind of international agreements that are signed, and probably some existing agreements will be revisited by some countries. And I think that if we are a bit pessimistic, but not too much, this shows the returning of protectionism, not only in trade, but also in investment, and probably an increasing number of conflicts that will be resolved more or less either by arbitration, but more probably at international courts. The real question is whether all the parties involved will accept the legal way and the way the trials are organized and the sentences that will be given by these tribunals. This is for me a question mark.
Thank you, Bruno. I'd like to move quickly to Chester. Sorry, we're running a little bit late already, but with that background, could you give us a sense of whether realistically there's going to be a lot of successful claims in investor-state arbitration against countries, host states that are trying to address the pandemic through various countermeasures?
Yeah, so thank you, Luke, and thank you to Luke and the organisers for inviting me to be involved in this webinar. So as Luke has just introduced, the focus of my brief remarks is how international investment law will be impacted or will have effects on what is going to be happening over the next few months and years. Whether there will be any claims under investment treaties arising out of measures that have been adopted by states to cope with the COVID-19 pandemic. And so I'm going to briefly look at this from the perspective of investors, so potential claimants, as well as from the point of view of host states who are potential respondents in these types of claims. Now, this is obviously a large topic which could fill an entire webinar, and indeed in the new Zoom and WebEx world that we now live in, there have been much fuller sort of considerations of this, but I'm just going to skate across the surface and pick out a few highlights of this issue. Now, states, we all know, have obviously had to adopt a range of extraordinary measures to cope with the global pandemic, including border closures, travel bans, lockdown measures of various sorts, stay-at-home orders, closing down businesses and industries, provision of subsidies and other financial support for individuals and businesses, as well as orders directing production facilities and factories to stop producing what they would normally be making and start producing things like ventilators and hand sanitizer and masks. Now, it may be that when the dust settles on all of this, and hopefully it will settle sooner rather than later, there will be some businesses who will find that they have lost their investment because it was requisitioned by the host state's government and it's now lost its value, or they simply, their investment has failed because they weren't able to cope with complying with the various COVID-19 emergency measures that were adopted. And if an investor is in this situation, it may be that they'll have a claim under an applicable investment treaty, which, as many of you will know, is a treaty between states by which the states involved, it may be a bilateral treaty or a multilateral treaty, agree to provide certain guarantees of conduct or standards of treatment in their treatment of foreign investors having the nationality of the other state party or of the various states parties to that treaty. Australia, of course, has about 20 or so bilateral investment treaties and around 14 free trade agreements with investment protection provisions in them, although not all have the provision that allows an investor to bring a claim against the host state, known as the ISDS, the Investor State Dispute Settlement Provision. But just briefly, the most obvious obligations that states agree to when they sign up to these treaties and become party to these treaties would be the obligation to treat foreign investors and their investment in accordance with the fair and equitable treatment standard, the obligation to not to adopt measures which are unreasonable or arbitrary or discriminatory in their application to foreign investors, and also the obligation not to expropriate the assets of foreign investors unless compensation is paid and certain other conditions are met. Now, just in the interest of time, because we're running short, I'll just briefly set out what tribunals have had to say about what the conduct is that's required of states in accordance with the fair and equitable treatment, or the FET standard. And there is a great deal of debate about this, and that's sort of a full day's worth of material, but just briefly, one of the best articulations is found in the award of the NAFTA Tribunal in the Waste Management in Mexico case, which is an award from 2004, so it's relatively ancient so far as investment treaty arbitration goes, but it seems to have stood the test of time. And the tribunal in that case said that a state had a duty to act in a way which was not arbitrary or grossly unfair or unjust or idiosyncratic or discriminatory. The host state had to act in a way which didn't expose the investor to any prejudice, and it had to also act in a way that didn't involve a lack of due process, which would lead to an outcome which would offend judicial propriety. And at all times, it's relevant to consider whether the host state has breached any legitimate expectations that the foreign investor had, whether the foreign investor acted in reliance on representations that were made by the host state in order to induce it to make an investment. Now, other tribunals have placed emphasis on different elements of the FET standard. Some have said that the state has to justify its conduct by reference to whether the measures adopted bear a reasonable relationship to a rational policy objective. Others have added that a state has to act in a way which is not disproportionate. And most tribunals have said in all of this that in considering whether the state has breached its duty, the tribunals have to accord a good deal of deference to a state's policy decisions. Now, I'm not aware yet of any claims that have been brought arising out of COVID-19 measures. It's probably still too early for that. One was mooted, if not threatened, earlier this year in April against the government of Bolivia in the context of a decision made by the government of Bolivia as part of its COVID-19 response to stop collecting tolls from the various highways in Bolivia. And there are a number of toll roads in Bolivia that are owned by a group of concessionaires who are foreign investors. And the prospect was raised that if this measure lasted longer than was reasonable, those foreign investors might seek to bring a claim, because they're of course losing money if people aren't paying the tolls on these freeways, where those freeways and their operation of those freeways constitutes their investment. Now, it's just not clear whether that has progressed beyond a mere threat. It may still be too early. And so there are these kind of considerations that investors will be making. Has the state acted in a way which is reasonable? Are these measures justifiable, or are they arbitrary? Are they linked reasonably to a rational policy objective? I think the rational policy objective is there, which is the protection of public health and combating the pandemic. But the question has to be asked in each instance, is this measure reasonable and proportionate in relation to that policy objective? Now, if the state is claimed, the state is faced with a claim, it may have a number of defences. If there's a claim for expropriation, there'll be the defence of police powers, which has been adopted by some tribunals in the context of public health measures in other cases. The second form of defence that a state might have, which is not really a defence, but there may be an exception in the applicable BIT, there may be an exceptions clause which says that nothing in this treaty will apply to prevent a state from adopting in good faith measures which are necessary to protect maintain public order or protect public health. And those don't exist in every treaty, but they do in many of the newer BITs and FTAs. And then finally, just briefly, there are a number of defences that arise under the law of state responsibility. They exist as a matter of customary international law. It doesn't matter whether they're in the treaty or not, and typically they won't be because they'll apply anyway. And these are all codified in the ILC's articles on state responsibility, including Article 83, which is a defence of force majeure, Article 23, which is force majeure, 24, which is the defence of distress, and Article 25, which is the defence of necessity. You know, these can typically only be invoked in fairly exceptional situations, and haven't been accepted in a great number of cases. Particularly the necessity defence has been invoked by Argentina in a number of claims brought against it, with varying degrees of success. Some tribunals have accepted it, arising out of it in the context of the Argentine financial crisis nearly 20 years ago. Other tribunals have not accepted it. That is a very, very brief overview of some of the issues, not at all an exhaustive, even an exhaustive overview, but hopefully I've skated across the top of the surface in a way that might prompt some interest in these issues, because I think we will be looking a bit more closely at these issues in the year to come once claims start being made. Thank you, Luke.
Thank you, Chester, and thanks for keeping to time. In fact, coming in under time. Fast track arbitration going on here. We have a question actually already in the chat from a colleague, I believe, from India about ISDS, but so we'll come back to this topic. But can I turn now to Rikyo University Professor James Claxton in Tokyo, who also serves as mediator and arbitrator, and as a co-commentator, if she's here, yes, Anna Ubilava, who's our PhD student at the University of Sydney, almost finishing up writing of her thesis on investor-state mediation, because the question that was posed in the event webpage is whether the possibility of arbitration claims by foreign investors under treaties might lead to more innovations in investment treaty making. And so one possibility would be greater uptake of provisions allowing host states to require mediation attempts before arbitration, which we found in the Indonesia-Australia Free Trade Agreement signed last year, which Anna and I wrote about in this forthcoming Clure book. But I'll give the floor now to James to see what he thinks will be the impact of the pandemic on the way investment treaties are being drafted.
Great, thank you very much, Luke. What I think I'd like to try and do with a short time is really three things. First, to provide a little bit of background about investor-state mediation for those who haven't looked at it closely. Then I'd like to consider how investor-state mediation is being promoted currently. And then at the end, I'd like to speculate a little bit about how investor-state mediation might develop. With regard to the background, the modern system of investor-state dispute settlement was actually inspired in large part by the mediation process. ICSID was set up with conciliation in mind, and yet both inside and outside of the ICSID system, arbitration has, of course, established itself as synonymous with investor-state dispute settlement. More than 50 years after ICSID was formed, with the legitimacy of arbitration now being questioned by some, there is renewed interest in investor-state mediation. The comparative benefits of mediation are manifest and include savings in cost, savings in time, and possibly even saving relationships between the parties, all familiar features of mediation generally. But mediation also offers some special advantages in disputes between states and investors. And I'll give two examples. One concerns procedural legitimacy. Mediation avoids questions about the legitimacy plaguing arbitration because the parties control the mediation process and any outcome. And another is legal exposure. So mediation can enable states to avoid taking legal positions that could later be used against the state. For example, it may be easier for a state to avoid committing itself to an interpretation of a treaty provision in mediation than in arbitration. So if mediation is well suited to investor-state disputes, what is being done to promote and facilitate the process? Well, the first thing to observe is that there's an appetite for mediation on both sides of the ledger. In a forthcoming Queen Mary University report on investor perceptions of ISDS, 64% of investors who responded favor mandatory mediation provisions in treaties. Meanwhile, on the state side, states are increasingly providing for mediation in their treaties, some with mediation rules, some with mediation codes of conduct, and as Luke mentioned, in the Australia-Indonesia treaty, mandatory mediation is provided for. And equally in the Hong Kong treaty with United Arab Emirates, the bilateral investment treaty, which came into force just last month, that also provides for a mandatory mediation mechanism. Meanwhile, institutions are working to improve the regulatory framework. So ICSID for the first time has published draft mediation rules, which are remarkable because they're open to all investors and states. They're not subject to the normal ICSID membership requirements. Institutions are also assuring that mediation is part of policy initiatives. You'll be familiar with UNCITRAL Working Group 3's work looking at investor-state dispute settlement reform, and it's looking at mediation specifically as an option. And then finally, there are capacity building initiatives, including trainings specific to investor-state mediators. So that's a quick background and an overview of the present landscape. Let me leave you with 3 thoughts about what I think will be important to determining whether there is more uptake of investor-state mediation, COVID, post-COVID, and in general. The first point that I think is extremely important is the inclusion of mediation provisions in treaties, a topic that I'm writing about now. And including mediation by name in treaties may help to normalize the process and shift the paradigm away from arbitration. But how mediation is provisioned in the treaties really matters. And there's a variety of approaches now in treaties. Treaties take different approaches with respect to the relationship between mediation and cooling off periods, for example, and they regulate mediation differently. And as mentioned, they differ in whether or not mediation is mandatory. Another key to greater uptake of mediation concerns the interface between mediation on one hand and institutional structures within states for processing and defending investor claims on the other. This is a topic I'm writing about with Carlos Jose Valderrama at the moment, and we're looking at how state response systems to investor claims can encourage mediation or at least limit obstacles to mediation. And a third dynamic that I think will bear on mediation's future is how mediation will engage trends now facing arbitration. One example of such a trend is the trend towards transparency in arbitration, something that Chester and Paula have written about. Another trend that will be interesting to watch is claim financing. So in an article with Anthony Nichols, we're considering how third-party funding and contingency agreements may be impacted by better prospects for mediation. I think that's about all the time I have. Thank you very much.
Thank you. And sorry, Anna, we'll have to come back to you if you on this topic, but I think it's going to come up in the final Q&A because I see a relevant question already. Can I turn now to my other colleague, Jean Huang, who is going to turn a bit away from investment disputes, but stay with FTAs. Do you think that based on your chapter written with Shanghai Jiao Tong University Law School professor Hu Jiaxiang, that Asia-Pacific FTAs could be redrafted to bolster their dispute resolution mechanisms and thus make more credible and effective referenced environmental protection treaties, but also WHO, World Health Organization instruments, so that we get a better response in future to any global pandemics, God forbid.
Thank you very much, Luke. So maybe I can quickly share my very short PowerPoint. So my chapter try to discuss, can free trade agreements and their dispute resolution mechanism help to protect the environment and public health? So it is not exhaustive research. Actually, it serves as call for more research. So my research at the very beginning is inspired by the criticism documented in scholarship that the international health regulation has a very weak mechanism. So I began to think about how to enhance its compliance. So actually the weak compliance is not only the issue that international health regulation is confronted. Multilateral environmental agreements are generally suffered from weak enforcement. So in these aspects, I particularly pick up MAPO. So actually the major reason I would like to use slides is because MAPO is not a very popular or widely loaded convention for practitioners. MAPO is was sponsored by International Maritime Organization. It is an international convention for the prevention of pollution from ships. So the primary treaty was drafted in 1973, and then there is a protocol in 1978. But the MAPO was widely ratified by the state. Okay. Since 2006, leading by the United States, there are 8 international free trade agreements or trade promotion agreements incorporated MAPO, which means that if a state does not comply with the MAPO obligation, actually the other state can use free trade agreement, the dispute resolution mechanism under the FTA to enforce the compliance. So this triggered my research interest. I try to look at whether international health regulation can learn something from MAPO and free trade agreements. So the reason why MAPO is particularly important among all the multilateral environmental agreements incorporated in FTA, because there are great similarities between COVID-19 pollution caused by the vessels. Why? Because COVID-19 is mobile, is human carried, and human is mobile. But if you look at the subject matter of MAPO, it regulates vessels, and the vessel is mobile as well. So the place of pollution is not practicable. And both, the damage from COVID-19 and the damage from the vessel carried or vessel sourced pollution are also cross-border. And the second very important issue to encourage my research is, if you look at the 2 international organizations, the culture in the international organization, World Health Organization and IMO, they are significantly different from World Trade Organization, which has a sophisticated dispute resolution mechanism. Instead, World Health Organization and International Maritime Organization, they are technical organizations focused on evidence and science. So in my chapter, I considered especially the CPTPP and how the CPTPP encourage states to comply with MAPO. So here I just go to my conclusion. So in the past 15 years, MAPO has never been invoked in any dispute mechanism under free trade agreement. But this does not mean free trade agreement is useless to enforce MAPO. Why? Because the free trade agreement, the dispute resolution, can significantly enhance the weak procedure aspects of MAPO. But besides procedure issues, we also need to look at the substantive issues and also the cultural issues, especially World Health Organization and International Maritime Organization. So actually my conclusion here is the availability of free trade agreement, compulsory dispute resolution mechanism is an undeniably important symbolic access. It may induce diplomatic cooperation, but whether free trade agreement can really effectively to enforce MAPO or enforce international health regulation. I think really more research can be done. This is my brief report. Thank you.
Thank you so much, Jean. It's a very innovative idea to extend the referencing of not just of environmental protection treaties like MAPOL, but say the WHO instruments, to have them included in FTA so that we get better enforcement of those commitments. And maybe this will be an area where governments will become more innovative as a result of this pandemic. But now we need to turn to a fifth question and have a look around the region in terms of what impact it's likely to have, particularly this dramatic move to virtual hearings and e-arbitrations in terms of relative attractiveness of different seats for arbitration. So we've got Shala Ali, professor at University of Hong Kong and co-editor of the Clue book, who's going to talk first a little bit about Hong Kong, and maybe also wants to touch on some of what we've discussed already about investor-state mediation, but perhaps we can also leave that for some questions I see on that topic that have been posted in the chat. Then we'll have some perspectives from mainland China from our Professor of Chinese and International Business Law, Vivian Barth, my colleague here at the University of Sydney and Director of the Centre for Asia and Pacific Law at the University of Sydney. And then finally, last not least, we'll have Dr. Nobumichi Teramura over there in Cambodia at the moment, but talking about the potential impact for Australia of this shift towards e-arbitration. Thank you.
All right, well, thank you so much, Luke and co-panelists. So I will start by touching on a few of the things that Hong Kong has been doing in regards to virtual hearings. We actually had a really interesting sort of test case. So in March of 22nd of March, which was somewhat in the middle of this pandemic, or the early stages when things started to get people stopped traveling and things were shutting down, borders were closing. The VIS Moot was scheduled to be held here in Hong Kong, the VIS East Moot. Some of you, I'm sure on this, I'm looking through the participants, I'm sure some of you acted as arbitrators, or some of you might have been coaching teams, etc. But this was a chance, I think, to really test out this idea of electronic arbitration. So we had, I think the decision was to go ahead with the VIS East, but to transfer it entirely online within about a week or 2 weeks notice. And so the institution that assisted with that is called EBRAM. It's a new entity that was developed in Hong Kong, and its primary focus is on electronic arbitration and some mediation, also service provision. But it was very impressive to see how that whole endeavor transferred online. So I had the opportunity to function as an arbitrator in a few of the rounds, and they had 71 teams who maintained their participation in this online format, and there were 250 arbitrators. And so there was quite a lot of this was happening simultaneously. So not only did you have the complexity of running a single arbitration with parties and arbitrators in various time zones, but you had multiple arbitrations at the same time. So that was encouraging, I think. I think it showed us that it's possible, and that decisions can be made, evidence can be presented, questions, discussion can take place, questions can be asked of panels, and that the system can move in this direction. So that was very interesting. So EBRAM, I mentioned, it's an entity that was set up quite recently, and it's just initiated in this month, I believe, COVID-19 electronic arbitration scheme, where parties can apply for this service for disputes that are under about Hong Kong 500,000, which is about let's say 40,000 US 50, say, give or take. And it's a subsidized service, and so this is allowing parties who have disputes both in Hong Kong or cross-border to apply and to find some remedy. And this really also touches on, I think, what was mentioned before. I see in a question someone's asking about moratorium period. And I've been following some of these developments, just the whole question of how do we resolve cross-border disputes, especially in light of a unforeseen event like a pandemic. What is the role of sort of, how can we approach these issues in new ways? How does this kind of crisis provide us with maybe an impetus to think of new ways of addressing the types of conflicts that we address? There was a very interesting effort by the British Institute of International Law. This was in April. They brought together economists and lawyers, and they also suggested this idea of a moratorium. They called it breathing space, but the idea is that during these sort of unforeseen crises, it's important to think creatively, and that if we were to sort of strictly enforce contracts the way we've traditionally done, this will lead to this, a deluge of litigation that will strain our international system of dispute resolution. And rather, what they suggest is looking at equitable adjustments to relationships so that no one is unintentionally enriched at the expense of another. And this really, I think, is something that mediation is well suited to. And we also have very strong institutions in Hong Kong that work with, for example, within the mainland, closer economic partnership agreement with mainland. Mediation is one of the provisions for investor disputes between the two regions. So I will leave it at that, and I'm happy to touch on any of those points later. But thank you again, Luke, and others for organizing, and I will mute myself now.
Thank you. We have a quick question from Fred Chilton, but we'll leave that until the last. Fred, can you turn Vivian to the situation in China and what potential this has for China to emerge as a more popular seat, perhaps, in the region?
Well, I think any seats at the moment are fairly theoretical. In terms of dealing with COVID-19, actually, the Supreme People's Court and the arbitration institutes have moved very quickly. I guess they've actually had the advantage that China was able to respond while everybody else was beginning to work out that they had an actual problem. But they moved fairly quickly to take a number of steps in relation to trying to keep the courts and arbitrations going. I have to say it's not clear to me how successful these steps have been, but nevertheless I'll talk about a couple of them. First of all, the Chinese were already trying out online courts. So they already had trial online courts going in Hangzhou, Beijing and Guangzhou, which started off in 2017, 2018. So they moved fairly quickly to then say that all courts could go on to online procedures. I would note here, though, it's probably easier for Chinese courts to go online than it is for your standard common law court when it's calling upon witnesses and very dependent upon argument on the floor than it is for the Chinese courts, which do a lot of their work on the papers anyway. Similarly, in relation to online arbitration, the Chinese arbitration institutes all had rules relating to online arbitration, though generally they have been used for e-commerce disputes and for fairly small disputes. But nevertheless, the procedures were in place, and therefore the arbitration institutes were able to step forward and say, well, we can actually do all of our cases online. Again, I don't know how successful that's been, because there is, even in China, a certain amount of resistance to doing arbitration exclusively online. But to the extent that it's done on the papers, then certainly you would be able to do that. And it was pretty impressive that the procedures were able to put into place to some extent so very promptly. The Supreme People's Court has also been fairly active in trying to put mechanisms into place in order to deal with disputes. And they've issued 3 opinions relating to essentially the civil courts operating in COVID-19. What's got quite a lot of publicity is their immediate response to talking about COVID-19 and the doctrine of force majeure. And as you probably know, the CCPIT and so on have been busy issuing certificates saying that an event of force majeure has taken place I think by about March, they'd issued 4,000 certificates to Chinese suppliers or to Chinese companies, essentially saying, yes, COVID-19 is an event of force majeure. The Supreme People's Court, though, has been fairly careful to say, well, these are not really evidence of anything in particular, other than that there has been, that COVID-19 has been there. So you would still have to, as a Chinese supplier, or increasingly buyer, I guess, have to prove to the satisfaction of a Chinese court that, in fact, the event of the alleged event of force majeure, that is your COVID-19 event, had resulted in the contract being unable to be performed. You can't just rely on your certificate. And I was noting online that there's already a case where some international companies have just refused to accept a certificate and said, well, you know, this really isn't worth the paper that it's written on. But it appears from the Supreme People's Court view of the matter that they are taking a fairly realistic approach. You can have a certificate, but you still have to prove that there's been an event of COVID-19, and you still have to actually prove that this has resulted in the contract not being able to be performed, though you could rely on hardship potentially in terms of delay. But they have also stepped forward in order to extend time limits for cases. In the third opinion, in relation to cross-border disputes, they've said very firmly to essentially to Chinese companies, you can't just delay a court case by relying on formalities. Chinese companies are very keen on getting everything notarized and authenticated and holding up court cases in that way. So the Supreme People's Court is trying to keep cases moving by preventing them from doing that. So the approach which has been adopted by the courts, I think, has been actually fairly realistic in an international context. Their idea is to keep the courts moving, to apply a realistic standard in terms of disputes about contracts being stopped. There's quite interesting comment actually made by Susan Finder in her blog in relation to the third opinion, because it reminds the courts that they have to comply with obligations under UCP 600 and the SPC opinion on demand guarantees. And this is apparently in response to a number of cases where Chinese international contractors who are worried that their demand guarantees or letters of credit which they've given as security for performance will be called upon trying to go to China in order to stop Chinese banks paying out. There are a number of previous cases of this. There's one very well-known English case where the UK court said, well, too bad. The Chinese bank, in this case the Bank of China, was based in England and gave an English law guarantee. So a Chinese court can't stop payment being made. But this nevertheless doesn't seem to stop Chinese companies trying from time to time. So overall, I'd have to say that the courts, at least in China, are trying pretty hard to keep arbitration and courts moving, and moving in a realistic and commercial fashion.
Thank you, Vivian. I think if courts are doing a good job moving online, dealing with these sorts of new disputes effectively, I think it does make people perhaps think about choosing those jurisdictions also as safe arbitral seats or more popular arbitral seats. But the last word has to go to Nobu about whether the shift to virtual hearings and these new types of disputes will lead to more attractiveness for Australia as a seat.
Thank you so much, Luke and organizers, for inviting me to this event. My point is this. At the moment, we don't know yet how the recent shifts to virtual hearings in arbitration will affect the attractiveness of Australia as a seat of arbitration. Why have I arrived at this conclusion? Because I have both optimistic and pessimistic views on the recent change. The optimistic view is this: Australia will overcome the persistent problem of distance thanks to the major shift to virtual hearings. As Mr. Albert Monichino, QC, and I pointed out in our chapter in the forthcoming book, Australia has rarely been regarded as an international or a regional hub for international arbitration due to the geographical remoteness. compared with regional competitors such as Singapore, Hong Kong, and Malaysia, Australia is a bit far from major economic powerhouses where cross-border disputes often take place. Of course, the seat of arbitration is a legal fiction, and therefore the parties who chose Australia as a seat would not have to conduct entire arbitral proceedings in Australia. Nevertheless, distance has always deterred parties from designating the country as a seat for the arbitration proceedings. The internet and virtual hearings may help Australia tackle the problem of distance as they make international travels unnecessary. So now we have online platforms, we don't have to travel all over the world. So staying at their comfortable places, parties may enjoy sophisticated dispute resolution services offered by Australian institutions. Overcoming the distance, Australia may become a more attractive choice for parties to have arbitration. And in fact, Australian institutions such as AFCA were quite quick in responding to the recent change. So this is my sort of optimistic view. But my pessimistic view is this. Australia will be exposed to further challenges from regional and international competitors. In a recent blog article from Crew Arbitration blog, Professor Luke Nottage stated, after all, arbitral institutions and practitioners across all credible arbitral seats are all busy presenting themselves as viable candidates in our brave new COVID-19 narrative world. I agree with Professor Nottage on this point. Since the outbreak of the pandemic, we have witnessed a growing number of webinars in which major arbitration institutions such as ICC, SISC, and HKISC emphasize that their online dispute resolution service is now available elsewhere, everywhere in the world, meaning those institutions are now trying to expand their market further and also trying to take opportunities from Australia. So Australia may be facing ever more aggressive challenges from foreign arbitration institutions. So this is my pessimistic view. And well, in the age of uncertainty, cautiousness is important. And I want to be optimistic because optimism is a virtue in Australia. But at this stage, it is still early to decide the impact of the recent shift to virtual hearings in Australia. The impact can be positive, negative, or even both. So further researching is absolutely necessary. That's all from me. Thank you very much, Luke.
Thank you so much. Thank you, Nobu. We've got a few minutes left for questions, and we've had quite a few, but I'm going to pass over to Stacey Strong. Thank you.
Excellent. Thanks, Luke, and thanks to all the panelists for their excellent and very rapid contributions. I think we only have time for 2 questions. So the first one I think I'm going to pose initially to Chester because that's where it came up, but the other panelists should chime in. It's the 2-parter from Srikar. The very first question, don't you think claims during the pandemic will further worsen the legitimacy crisis of ISDS? Do you support the ISDS moratorium during a well-defined period of the pandemic called for by some groups? And then the follow-up is talking a little bit more about whether the question of the moratorium is dealing with possibly mediation as another regulatory tool to work during the pandemic. So Chester, let's start with you, and then maybe a couple other people if they want to chime in rapidly, and then I do have one last question from the list to wrap it up.
Hey, thank you, Stacey. I'll just talk briefly to the question of the moratorium on claims in the COVID pandemic. And I don't support that. Basically, I think that it runs the risk, raises the possibility of states using that as a cover for some kind of action which they would otherwise not normally be permitted to take. It would be a breach of their obligations, and it may be possible for that kind of conduct to, whether it's an expropriation, whether it's wanting to get rid of some foreign investor they have had a difficult relationship with. I can just see the possibility of abuse And I think that for states who are acting in good faith and adopting measures which are based on scientific evidence and scientific advice, there are sufficient safeguards in the current system, both by reference to the contours of the obligations that they've accepted, as well as some of the available defences, which I mentioned briefly. I'll just leave it at that to give others a chance in the interest of time. Thank you.
Excellent, thank you. Anybody else want to jump in on the moratorium question?
Hi, Stacy. Can I ask whether an investor can bring a claim against a state for state fail to effectively enforce COVID-19 containment measure? Because yeah, that's possible, right?
She is the American on this. I don't know where that might be going.
We do have some people from Melbourne too. Be careful, Jean. Yeah, but it's a good question.
It is a good question, yeah. Anybody who knows a lot about investment, I mean, one of the questions I had for Chester was whether there were any investment cases that were looking at reasonableness. He talked about necessity a bit, but reasonableness in the public health context, whether there were any other pandemics that had arisen that he was aware of. Sorry to put you on the spot again, Chester.
I'm not aware of any investment treaty claims arising out of this kind of issue, SARS or MERS or any of the public health emergencies of international concern that have been declared by the WHO in the last sort of 10 or 20 years. So no, but certainly all the time there are cases where a tribunal has to assess the reasonableness of a measure that's been adopted, which has been adopted in the interest of to promote public health, to protect public health, where a kind of a substance has been in the past produced and all of a sudden there's scientific evidence to show that it's harmful to public health, to human health and the environment. Measures are introduced to ban the production of that substance or the sale and distribution of that substance, and claims have been brought. And in some of those cases, it's been found that there was no breach of the obligation because it was a reasonable measure based on a rational policy objective. In other cases, there might have been a successful defence by the state because it was a measure that was adopted that was not discriminatory, that was of general application, and it was adopted in good faith, and there hadn't been any kind of legitimate expectations that the investor had reasonably relied on that the state would never adopt that kind of measure. I suppose one recent example in the public health context is the Philip Morris claim against Uruguay, which did go all the way to the merits in contrast to the case against Australia, where Uruguay was successfully able to defend its adoption of not plain packaging, but certainly tobacco control measures and packaging requirements for the sale of tobacco products on the basis of the police powers doctrine, which I mentioned briefly in my remarks earlier. Thank you.
Absolutely, and points also to Marina Kaufman, who got the Philip Morris versus Uruguay decision also in the notes. I just want to, for our final question, turn it back to the mediation issue, which was kind of in our middle there. And there's a question from, I apologize for butchering your name, Naomi Masmusi, sorry, totally got that wrong. I was having a John Travolta moment. Do you think investor-state mediation would be a viable mechanism when the admission of amici curiae proved to be necessary for the underlying dispute? So one of our mediation folk, would you like to jump in on that? Shala, maybe?
Sure. I mean, I'll just, you know, there was an article I wrote about transparency with a colleague. We're looking at, yeah, whether some of the principles that are being addressed for investor-state arbitration, some of the UNCITRAL rules on transparency, whether there could be some shift to application within the mediation context. And that is a possibility. I mean, over time, there is a real value in sort of moving towards transparency. And I think it's a tricky one because many people gravitate toward mediation for the sort of flexibility and creativity you get by having some private space. But there is also real public interest involved in anything involving state funds. So it's a very tricky balance, but I think something to explore, and it can be done. We've had many sort of public scale, publicly viewable mediations. I know in the US on water rights for rivers with native tribes looking at sort of various fishing rights, and that was all held in the public domain, and that was and they were all successful and they were all carried out. So it is possible. I can pass it over to James if he has anything else to add.
Actually, James, sorry, we're probably just a bit out of time, and that's I'm sorry for having to wrap it up now, but we designed this webinar to just give everyone a taste of how the pandemic is influencing a range of international dispute resolution mechanisms, especially around the Asia-Pacific region. And I think we've shown that there's a lot more to discuss and think about. These sort of cross-cutting issues, I think, are going to be with us for a long time. And as I said, we're looking forward to when the book is out, having another look at this, maybe with the benefit of more developments and responses from different countries and different types of disputes that actually have emerged, so that we get a clearer picture. But can I just end by thanking all the speakers, and including Stacey for doing a very good job trying to curate all the questions. We've got a record of those questions, so we might come back to you individually as the coordinators of this session, or some of the presenters might come back to you later. Thank you for putting those questions to us to give us something to think about, and sorry we couldn't address them all today. And lastly, can I just thank the University of Sydney Law School events team and tech support, Andy Nerrington, Simran Singh in particular, because they've done a terrific job running not just this webinar, but a whole series for the law school. So thank you everyone for joining, and we look forward to seeing you again.